Good morning. Welcome to the second day of the Canadian Civil Liberties Association's 24th Annual Borovoy Conference on Rights and Freedoms. My name is Brenda McPhail. I direct CCLA's Privacy, Technology and Surveillance program, and I'm here to welcome our wonderful speaker this morning, Cynthia Khoo, who will be talking about a report she and some colleagues recently published in this talk that's entitled To Surveil and Predict: What does algorithmic policing mean for our constitutional and human rights? As Cynthia speaks, if you think of questions you'd like to ask her, please type them in the question box. It's labeled with a little question mark on the side of your screen. If you're in a classroom, students may have to tell their teachers what the questions are, but we really do encourage you, as it pops into your mind, feel free to enter them into the box, and they can either be woven into the presentation or we'll do our very best to get to all of your questions at the end. Our speaker, Cynthia Kuh, is a technology and human rights lawyer at Tekhnos Law and a research fellow at the Citizen Lab. She holds an LL.M, a master's degree in law from the University of Ottawa, where she worked on interventions in cases before the Supreme Court of Canada as junior counsel at the Samuelson-Glushko Canadian Internet Policy and Public Interest Clinic. That's a mouthful. We call it CIPPIC. Her work spans across key areas of digital rights, law and policy, including privacy and surveillance, platform regulation, freedom of expression, equality, and technology-facilitated abuse. Please join me in welcoming Cynthia Khoo. And Cynthia, you're live.
Great, thank you so much. And just to check, my slides are up?
They are coming up right now. There you go.
Perfect. Thank you so much, Brenda, for that introduction. And thank you, everyone, for attending this workshop. Just to give you some context about this project and how it came to be, it was a joint investigation that took place over 1.5 to 2 years between the Citizen Lab, which is an interdisciplinary research laboratory at the University of Toronto that does mixed methods researching at the intersection of information and communication technologies, global security, and human rights. And then our partners were the International Human Rights Program, which is a legal clinic at the University of Toronto Law School. So there were 3 of us actually working on this project. We collaborated on it as equal co-authors. There's myself, who is a technology and human rights lawyer, alongside Kate Robertson, who's a criminal defense attorney based in Toronto and also a Citizen Lab fellow, and Yolanda Song, who is a international human rights and civil litigator. So it was a really great project because we all got to bring our expertise to bear on this particular issue. So to begin with, I want you to think about some of your day-to-day activities and the ways that you use technology, whether it's to communicate with friends, keep in touch with your family, seek information, if you drive a car, or if you're walking about through different neighborhoods, if you've ever seen a block watch area, or maybe some of you have been stopped by the police and carded in Toronto, for example, and have had your information taken down, or maybe you've attended a public protest. Or if any of you were paying attention to the Google Sidewalk Labs issue, eventually smart cities may become a thing. So just keep all of this in mind as I go through this presentation, and I want you to think about how the types of technologies that we'll be discussing might impact the ways you use these technologies or your general thinking around them and what might happen as a result of that. So just to give you an overview for where this presentation is headed, first I will give you an introduction of what exactly is algorithmic policing. What are algorithmic policing technologies and how are they different from conventional policing? Then I'm going to go over some of the key human and constitutional rights that our report found algorithmic policing technologies pose a significant risk to if they're allowed to proliferate across Canada unchecked. Specifically, they are the right to privacy, the rights to freedom of expression, peaceful assembly and association, the right to liberty or freedom from arbitrary detention, the right to equality and freedom from discrimination. And all of these, of course, are protected in the Canadian Charter of Rights and Freedoms. Then I'll wrap up with just a few higher level takeaways that I think it would be useful for you to leave this presentation with in terms of more conceptual thinking about law and technology and the relationship between them. So what is predictive policing? classified algorithmic policing technologies into two separate categories, the first of which is predictive policing. So if any of you have seen the movie Minority Report, I know that's often the first thing that comes to mind when people think of this type of technology, because it's the idea of police predicting crime where and when it can happen before it actually does happen. Location-focused policing is one example of that. Another is person-focused predictive policing, where they take all this information about a person, like their social media activity, their friends and family relationships, their history, their employment records, and try to predict what is the likelihood that this person is going to commit a violent offense in the future, for example, or if they've been arrested, what is the chances, based on what we know of them, that they are going to do something considered criminal again. Then on the other side, we have what we call algorithmic surveillance technologies. These do not claim to have a predictive element, so they're not going to tell you a crime is going to occur in this neighborhood between these 2 hours, and they're not going to say this person has a 90% chance of committing X crime. But instead, they take in data ubiquitously, so based on artificial intelligence. They include facial recognition technologies, social media surveillance, automated license plate readers. So if you've ever seen a little device by a traffic light as cars drive through, it's scanning the license plates and reading them, and social network analysis, which basically analyzes social networks that they can find online to figure out how are different people related to each other, who are key players in different social networks, who are central people in different friend groups, on how might that relate to gang databases, for example. And so even though algorithmic surveillance doesn't necessarily have a predictive component, because of how invasive and far-reaching it is and the dragnet nature of that surveillance and data collection, it can still pose just as much of a human rights danger, if not more, as predictive policing. So earlier, I mentioned to think about some of the day-to-day experiences or activities that you might have had. And the reason I brought up these ones in particular is because these are basically all the channels through which algorithmic policing technologies are being used. So we have location-based predictive policing, which informs block watches. Person-based predictive policing can be based on information in police databases. Social media surveillance and social network analysis is deployed throughout Twitter, Facebook, whatever social media app you can think of. Facial recognition technology, one of the main fears of human rights and civil liberties advocates is that they will eventually be used as protests if they aren't already, to identify who is attending a protest, who is involved in which particular social movement. And then, of course, automated license plate readers have already been in place for years. And so when you put all of these together, they amount to essentially different combinations of just algorithmically powered mass surveillance across a city. And this is before we even have smart cities. So it's worth thinking about what will happen in the future if, there are sensors installed in sidewalks, if restaurants are able to detect who is walking by and they have a back channel to the police, and so forth. So what makes algorithmic policing different from traditional policing or even big data policing? It comes down to what's known as the 3 V's: volume, velocity, and variety. Algorithms and artificial intelligence just ups the ante on all 3 of these things. Volume is in the sense that you can now collect so much more data than any human possibly could, just as a matter of physics, because of what the technology allows you to do. Same thing with velocity. Before, you would have to wait for a computer to process or wait for a human to complete that data entry. And now, not only can you take in extraordinarily high volumes of data, but you can take it in and process it in real time, and then have the algorithm spit out particular forecasts that a police officer can then act on. And then the third V is variety. So now, for the purposes of criminal investigations, police will not only be able to access the data that they themselves can collect through their investigations, but if schools collect data, hospitals collect data, stores collect data, think of all the social media platforms that we've seen hand over data to law enforcement, whether that's Google location data, Facebook data, what else? Private surveillance companies or security companies, all of these other agencies, whether they're non-police government agencies or private companies, because the data is so easy to transfer and so portable, it's possible for police officers to request or to set up arrangements where they are now also taking in this wide variety of data, which lets them form linkages between them. So they can trace one person and say, okay, well, we saw this person in a neighborhood. We have this card about them. They were at this place at this time. They have these friends on Facebook. They talk to these people on Twitter. This is their license plate. And taking all of these together form a really intimate profile of specific people in a way they would never have been able to do 10 or 20 years ago. So that's the main difference. Bring all this together. This XKCD is one of my favorite webcomics, and this is actually a particularly great one on the topic of predictive policing because it's often compared to a weather forecast. There's no certainty. It's just a statistical generalization. It's a probability, but police officers are still told that they can rely on them in order to make decisions that can impact people's civil liberties and human rights. And this comic I like because it actually illustrates a few of the problems that we have with algorithmic policing, such as bad data, patterns that break on you, in this case, days of the week, that pattern has broken, and what happens when you put in wrong data and then that impacts the output. And so that's known as the garbage in, garbage out phenomenon. In this case, they typed in a negative zip code and they apparently brought about the apocalypse. So again, just like thinking about these problems and how they relate to some of the issues that we'll be talking about later on. So on to the actual rights. How do these algorithmic technologies impact each of our key human rights? Starting with the right to privacy, covered under Section 8 of the Charter. The right to privacy protects our zone of human flourishing. We cannot necessarily thrive if we're constantly in public at all times. We need quiet spaces to ourselves to just think over things, to figure out who we are, to develop our own identities. So how does algorithmic policing impact the right to privacy? Through 4 ways, specifically data collection, data processing, data sharing, and data accuracy. So going over these quite quickly, the slides will be kind of detailed. I will be going over them, but if you are keen, you're welcome to read the slides with the more detail. So the first thing being data collection, that is what I was mentioning about the transformation of public space. If you're walking down a sidewalk and there are sensors figuring who you are, you attend a public protest, and now there's facial recognition technology, again, identifying who you are, or you log onto Facebook or Twitter and you can no longer spout off on whatever you want without wondering in the back of your head, oh, is there a police officer who's systematically monitoring my words? That's going to impact how people exercise their ability to freely express themselves. Next is data processing. So once that data is collected, what's done with it? It's fed into particular algorithms, but our laws haven't caught up with the different ways that collected data can be used. And a great example of that is facial recognition systems are now being used on mugshot databases. So police collect mugshots under a specific privacy regime that lets them do that for certain purposes. But that regime never contemplated the existence of facial recognition when it was drafted. So is it legal for the police to repurpose those mugshots for the use of putting them through facial recognition technologies to try and identify suspects based only on people who are already in that database in the first place, whether they should be there or not? The third issue is data sharing. So this goes back to what I was saying earlier about how it's not just police officers now, or law enforcement agencies who have data that will be used in criminal justice investigations, but because of data sharing avenues, you can have non-police agencies such as schools, hospitals, social welfare agencies, employment agencies, and private sector companies such as social media platforms, Starbucks, Aritzia, just private companies that don't have any public function at all, potentially sharing their data sets with the police as well. And so what are the constitutional issues that come up there when you have one privacy law applying to non-police actors, another privacy law applying to police actors, but now they're all mixed and the law hasn't recognized that yet. So you can see here in the example that Ontario Police used a COVID-19 database, and it was actually the CCLA that found this. So this is a perfect example where everyone thinks, okay, I'm going to give up my data for health, and then without being told that health data is being repurposed for police uses. And then finally, data accuracy is that data even right to begin with? The police are collecting all these data on people, but we've seen that regardless of what the data is, whether it's carding or street checks or gang databases or arrest records or convictions or guilty pleas, our research found that every single one of these types of data is biased, is disproportionately biased against Black and Indigenous and racialized people. And it's also just inaccurate. For example, many guilty pleas are not on the basis of actual guilt, but because people couldn't afford to fight the case, for example, or they just want to get home and not spend time in jail. And the easiest way to do that is to file a guilty plea, even if they have a defense, even if they weren't guilty. So that data isn't reliable, but it's being used to train algorithms that are informing future arrests and detentions of other people. Next, we come to the right to freedom of expression, peaceful assembly and association. And this is really where the social media problem comes up in terms of police, monitoring social media, depending on who you are. So the Canadian law enforcement has had a terrible track record of monitoring Canadians' social media activity without consent, without notice to the public. So for example, the RCMP was spying on people on social media for over 2 years before the Tyee broke that story. Again, the RCMP recently awarded a grant, obtained a much more sophisticated social media surveillance tool called Babel Street that has links to the US intelligence and defense communities. And the reason this is so problematic is that the RCMP assumes that if you've posted something on social media, you automatically waive all of your privacy interests in it. But that's not necessarily true, because privacy isn't about whether or not you have just made something public at all or not public at all. Privacy is about choice and control over your information. If you have 2 Instagram accounts, for instance, just because you post something on one account and that account happens to be public, it doesn't mean it's now fair game for everyone. There's a reason you have a second account. The whole point is that you control who sees what. And that's what privacy is at core. Not either everyone can see it or no one can see it. It's a lot more nuanced than that. But that's not the understanding that the RCMP has. They think that as long as you post it online, it's fair game, which is not all the case. The Supreme Court has recognized that's not necessarily the case, particularly when it comes to state surveillance. Just because you post something online, it's one thing to think that, okay, I know people will see it if they happen to come across it, and it's another to think everything I post is going to be systematically monitored and analyzed by the police for criminal justice purposes. And so this is where freedom of expression comes in, because research has shown that if people even suspect the government is spying on them, then they do engage in self-censorship. And so we call that the chilling effect. Another thing that's particularly troubling when it comes to social media surveillance is that law enforcement agencies tend to target equality-seeking social movements. So Black Lives Matter, for example, Indigenous rights defenders, there have been many documented instances of law enforcement surveillance targeting these social justice movements. And the companies themselves, Media Sonar, for example, was banned from Facebook and Twitter a few years ago because it was found to be advertising to police agencies in the US that they could use this tool to specifically monitor Black Lives Matter hashtags. And just last week, actually, 2 weeks ago, at the end of November, we found out that Brian Carney at the Tyee found out that the RCMP apparently has a tool that can where they can basically break into your private friends list on Facebook. Even if you've made those lists private, this tool can apparently not make them public, but can reveal them to the RCMP or whoever holds that tool. Which of course goes to our right to freedom of association, because if you can't really connect with who you want on social media sites, even in privacy, because they now have this tool to break in, what does that do for your ability to maintain those relationships and associations? Which leads us to the right to liberty. And that's the ability to basically move freely around and not be randomly stopped in the street by a police officer for no reason. So one way to think about how algorithmic policing technologies can impact the right to liberty is to think about location-based predictive policing, because that is based on where you are. It's based on neighborhoods and time and place. One example of this is the Geodash algorithmic policing system, which the Vancouver Police Department uses. And how it works is it uses machine learning algorithms to predict every 2 hours the top 6 neighborhoods in Vancouver where property crime is most likely to happen. So some people would think this doesn't seem like such a human right concern because they're not looking at people, they're just looking at neighborhoods. But when it comes to the right to liberty under Section 9 of the Charter, that's precisely the problem. So how Section 9 works is that you being detained by the police is unconstitutional if they've done it without reasonable suspicion. Reasonable suspicion has to be specific to you as an individual. It has to be how you specifically look or something that you're doing that makes you suspicious. But how location-based algorithmic policing works by definition is that it's not about you at all. It's about the neighborhood. It's about the fact that you just happen to be in the wrong place at the wrong time when an officer was sent there told by a computer a property crime is going to happen, and so therefore are probably more on alert and more ready to be suspicious in the first place. So if you imagine 2 scenarios, in one scenario, someone's running down the street with a backpack. Maybe they're late meeting a friend, maybe they're late for school. And that's it. That's a fairly innocuous situation. In situation B, exact same scenario, but now a police officer has been sent to patrol that neighborhood because they've been told that an algorithm has forecasted a property crime is likely to happen here in the next 2 hours. So now the officers there, they're looking for a crime that they're told has a certain percentage of happening. And then they see someone running down the street with a backpack. Maybe that person suddenly looks like a thief and not just someone who's late for school or late to meet a friend. In both scenarios, nothing changed about the person. It was just the algorithm affected the whole scenario in the officer's mind. So that you would think would violate the principle of reasonable suspicion being tied to the individual and not being generalized suspicion based on the location or the neighborhood. However, even if the police officers know this, then we run into the problem of automation bias, which is the idea that people tend to trust machines and computers more than we should, even if we know we shouldn't. And so even if an officer is trained not to do that, they can't necessarily stop themselves from unconsciously doing so anyway. And then finally, we have the issue of racial bias and racial profiling, which is not the type of blatant discrimination that you might think of when you think of police engaging in racial profiling, but it's a much more subtle form that's embedded in the algorithms themselves. And so this is known as math washing, because you have what used to be racial profiling now embedded through data that reflects past racial profiling, embedded as part of the algorithmic model itself, which then spits out those answers, but it no longer looks like a racist cop doing that. It's just the algorithm, it's just math. And so you're using that algorithmic veneer of objectivity, scientific neutrality to hide what in the past would have obviously been racial profiling. Which brings us to the right to equality and freedom from discrimination. This I kind of think of as almost a meta right, because if you think of the right to privacy, freedom of expression, and liberty being more vulnerable if you're Black or Indigenous or from a racialized group or have a mental illness, for example, or a disability, then your enjoyment, your ability to fully benefit from the right to privacy, freedom of expression, or liberty are disproportionately impacted compared to other people who are not in these groups, which then also engages your right to equality, in addition to the ways that algorithmic policing technologies on their own already violate the right to equality in other ways. So one example of a way to think through the right to equality is an example of person-focused predictive policing that we have in Canada. This one is not live yet. They're still in the research and development stage, but it's the Saskatchewan Police Predictive Analytics Lab. It's a three-way partnership between the province of Saskatchewan and the Ministry of Corrections and Policing, the Saskatoon Police Service, and the University of Saskatchewan. And so what they are doing is they're taking things like people's risk factors, behavior patterns, social media, social services information, if they've ever gone to access social services, turning all of this into data, making algorithmic models in them, and then trying to predict what might happen with a certain person. So they're starting off interestingly, trying to predict future victims, for example, missing youth or runaway persons. But in the future, they've said eventually they want to try and start predicting violent offenders, for example, or repeat offenders, or developing algorithmic models to address the opioid crisis. So how does algorithmic policing and systems like that engage the right to equality? Well, first is the idea of feedback loops of injustice. Algorithmic bias can increase already heightened scrutiny, suspicion, and aggression against members of marginalized communities. If you think about someone being carded for no reason, their information is now in a police database, which means that the information, they are much more likely to come up in a future search for potential suspects, even if there is no reason for them to be in a database in the first place. And if you think of how Black, Indigenous, racialized individuals are disproportionately targeted for this kind of carding, you multiply that over populations, and over time, you can start to tell that database is going to look a certain way, and it does look that way already. And so algorithms will only exacerbate and entrench this pattern even more. This is also not just a race issue, it's a class issue as well. So Virginia Eubanks talks about socioeconomic status and data hypervisibility. That's the idea that some people are just more visible to the government and law enforcement than others. If you're a homeless person, for example, there is no place indoors that you can stay for a long period of time. So you are just outside in public for a much longer proportion of the day. If a police officer is strolling through the street, you are just there in front of them to catch their attention. And so physically, you're more visible, but also digitally, people who access social welfare services or need food stamps or housing, for example, have to give over massive amounts of data in exchange to get those survival needs met. And so now all of their data is in these government databases, which again may have linkages to law enforcement. And so not only are they more physically visible on the sidewalk, but they're now more digitally visible through these databases as well. And so what you end up with is what you might think of as inequality by design, because it's now built into all of these technological systems and algorithmic models, and all of that inequality just kind of gets buried beneath that layer of math and science and algorithmic mystique. This is especially exacerbated by the idea of Techno Solutionism, which is the idea that technology can solve all problems, no matter how complicated they are. So think over all of this, which is a lot, I know. What are some takeaways? So I'm going to take it to a way higher level and go over 3 takeaways that are not even just about algorithmic policing themselves, but they are ways that you can think about law and technology in general, whether it's facial recognition, whether it's like YouTube algorithms, whether it's surveillance, other types of surveillance technologies, for example. So there's 3 main things that I'd like you to take away. The first one is the idea that technology is not neutral. I've talked about all these ways that policing algorithms can impact different groups to different degrees, depending on pre-existing discrimination. And that's the idea that technology is closely tied to power. It can shift and rearrange power, but it can also concentrate power, depending on who has it and who uses it. Langdon Winner is a foundational thinker in technology, law, and policy, and he wrote a great paper called Do Artifacts Have Politics? And that's the idea of, if technology is designed a certain way, technology can be political because of how it's designed. If you think of a gun, for example, to take it, old school, a gun is designed for a very specific purpose. It's not neutral because there's not that many things that it can be so easily used for. And so technology is very much the same way. If you think about how YouTube algorithms are designed, they're designed to optimize engagement. Police algorithms are designed to facilitate mass data collection and identify people even before a crime necessarily happens. So they lend themselves to certain functions and therefore certain power structures and ways of thinking and ways of structuring and ordering society. The next thing, speaking of society, is that technology cannot solve all society's problems. So you've heard of the saying, if you have a hammer, everything looks like a nail. You can think of that with policing algorithms as well. If you have an algorithm, everything looks like data that you can just mathematically crunch and magically feed into an algorithm and solve poverty or solve crime. But of course, we know that's not the case. If you think about what the root causes of community unsafety are, for example, it's things like systemic racism, underfunded healthcare, underfunded education, lack of housing. And these aren't problems that algorithms will solve. They're social and political problems, not technological problems. And finally, as a takeaway, is that as technology evolves, our constitutional and human rights and our laws protecting them also has to evolve. So this quote here I actually got from a speaker at a privacy conference several years ago, and she said everything was changed for everything to remain the same. And that just speaks to the idea that all of the laws we have today protecting our human and constitutional rights were written at a time before facial recognition existed, before social media surveillance existed, before Clearview AI existed. And so in order for us to maintain the same level of protection that we were supposed to have 10 or 20 years ago, because police capabilities through advances in artificial intelligence and algorithmic technologies have enabled them to go so far beyond into the zone of what our protected rights should be, our laws also equally have to change and evolve to keep that zone protected at the same size that it was supposed to be in the first place. Otherwise, technology will only make it shrink and those rights will erode over time unless we actively update our laws to protect them. And that's my presentation. Thanks very much. If anyone have questions, feel free to have at them.
Thank you, Cynthia. That was really interesting and really detailed. We do have a few questions in the queue already, and I'd encourage all the teachers and students out there to add to that queue. The first question is, how are the police getting into my Facebook account? How are they monitoring social media?
That's a great question. So police are not necessarily getting into Facebook accounts. We don't have evidence of that. When we say that police are monitoring social media, generally we are referring to publicly available social media. So it's if your Facebook page is set to public, then they are more likely to be monitoring it. We don't think, for example, that police officers are breaking into Facebook accounts. And a lot of the times when we think of social media surveillance, it's Facebook, but it's also Twitter, because everything is public on Twitter. And so they consider that fair game. Having said that, so the default is what's already public, which is already problematic because just because it's public doesn't mean the police have a right to spy on it. Having said that, now that we know the police have this tool that suggests they are at least breaking into people's friends lists that are set to private, and we also know that there have been examples of police say becoming Facebook friends with targets of surveillance and then getting access to their Facebook pages that way. So again, it's not like there's no hacking being involved. There's no hacking involved, but there are ways that are kind of suspicious or illicit that they're accessing your data. So I guess in terms of the most basic barriers, make sure all your accounts are set to private if that's something that you are really concerned about. But I think it's also dangerous to focus too much on, if you don't want to be spied on by the state, you have to shut down all your social media accounts, because that's the wrong way to go, right? Like, it should not be our responsibility to get off the internet and hide on our activity. It should be the state's responsibility to ensure that our human rights are protected when we're engaging in legal activity online. Okay, the next one, are police in Toronto using algorithms and predictive policing? So Toronto is, as far as we could tell from speaking with them, are not using algorithmic, they're not using any predictive policing yet. That's something they might be interested in doing in the future. At this point, they aren't. But what Toronto is one of the leaders in is facial recognition technology. So they were using facial recognition for over a year before the Toronto Star published about it. And as far as we know, they're still using it. And then when the Clearview AI story broke too. So Clearview AI, for those who don't know, is a company in the United States that scraped about 3 billion photos from the internet without anyone's consent or knowledge to create this really powerful facial recognition system. And it turned out that all these police forces in Canada were using it, were trying it out without anyone knowing. And one of these forces was Toronto. So Toronto is using all of the algorithmic surveillance technology, such as facial recognition, automated license plate readers, also social media monitoring. But as far as we could tell, they have not gone into the predictive stuff yet. But it doesn't mean they might not in the future. Is information from my school being sent to police? I don't think I can answer that. There is an initiative known as hub tables, which are tables that bring together different non-policing agencies with government agencies, such as sometimes schools, but not necessarily always, I don't think, or hospitals or social services and police, to see if someone might need extra help. For example, not everyone that comes to the police's attention is appropriate to go into the criminal justice system, right? Maybe they need a job, or they a mental health issue. That isn't a job for the police. And so what these hub tables do is that they can transfer them. But sometimes the information goes the other way, right? Like maybe someone will end up going towards the police as opposed to away from them. So that's just something to be aware of. Is there any way to fix the problems of biased data for training or getting used by police items? That is an excellent question. So my co-authors and I came to the conclusion that we don't think there is, because there is no unbiased data. All of the data that exists is biased, because data just reflects human choices and decisions. And if you look at the entire history of the Canadian criminal justice system and of colonialism and slavery and all of those various forms of systemic oppression that are continuing to this day, that is where all of our data comes from. So our data will reflect those patterns. And there isn't necessarily a way to clean that data out. And the other thing too is that even if we did have perfect data, that won't necessarily solve the problems, because in some ways the very existence of the technology itself, again, can shift society. If you're only looking at property crime, for example, then who generally tends to commit property crime? It's people who are poor, who lack material resources. And so if you only have algorithms that are catching property crime and police become really efficient at catching street crime, then algorithms are going to send police officers to the same neighborhoods over and over, and to only catch like street level people, maybe lower income people, depending on what the algorithm does, and instead they will not necessarily be looking at other types of crime. So for example, some researchers in the States created something called a white-collar crime heat map that only focuses on the financial district in Manhattan, so on Wall Street, basically, to analyze who are the most likely to be the criminals on Wall Street. And this was meant as a joke, but it was a really effective satire, because the whole point, of course, is why hasn't anyone created a predictive algorithm to catch white-collar crime or corporate tax evasion, for example? Why is it only street crime that they're interested in? So even if the data is perfect, the technology may still have higher level problems. Babel Street, how's that being used here, and how's it used in the US? So we're not completely sure if it is. So how it's being used is that it has only been recently acquired by the RCMP. They put up a tender in April, and then a few months after that, we found out that they'd awarded the tender to Babel Street. Having said that, if you look up Brian Carney at the TIE, he's been writing a lot of articles about the RCMP and their social media surveillance tools, and he's found some evidence from internal documents that they may have been using Babel Street too, again, for social media surveillance in the past without public notice. What are Toronto police using facial recognition for, and how are they getting people's photos? So they're using them in the context of criminal justice investigations, and in terms of getting people's photos is through video stills, for example, and then comparing them with mugshot databases. And so that's why one of the problems is looking at who ends up in these mugshot databases in the first place. Are there any laws that need to change in order to stop the police using algorithms? Great question. We actually do recommend multiple legal reforms in our report to either stop police using algorithmic policing technologies, or at least to do a proper full inquiry into what the implications and impacts of different types of technologies are, and one, figure out if it is possible to use them at all without a negative impact on human rights? And in some cases, the answer will just be no. So with facial recognition, for example, multiple cities in the United States have already banned it outright because they found it's too dangerous and it's not worth it, and there's too much of a risk to human rights and civil liberties. And with other types of technologies, then it may be more a matter of implementing reasonable safeguards and limits on how and when they can be used. Okay, I just saw the question on facial recognition, so I think I might have just answered that with the comment on the United States. Because if you think about facial recognition, it is such an intrusive use of such a public feature, I guess is the way to put it. There's no way to hide or conceal your face. And in fact, I don't know if anyone caught on the free expression slide with all the screenshots of the different headlines. There was a man in the UK who purposely tried to cover his face while walking past a facial recognition camera, and he got fined for it. And in Canadian law, there's a law that says that if you are at a quote unquote unlawful assembly and you have a face covering, like that is also illegal. So the idea that you are forced to not cover your face and then might risk having to be your specific identity revealed whenever you go somewhere in public is, I think, not something that we would want to happen in a free democratic society. If there aren't any clear unique okay, this is a good question. If there aren't any clear unique identifiers to social media accounts, such as someone's name, how would police identify who is the owner of the account in question? So there are a couple ways this could happen. One is they could actually go to the social media company and see if there's any back-end information from that company to identify who that account is. Another way they could possibly do it is by tracing that person's IP address and then going to the person's ISP, internet service provider, who will then have, even if the social media company doesn't necessarily have your real name and information, your internet service provider will definitely have your name and address and credit card and so forth. And so that's one possible way that they might find out who that person is. Have there been legal cases where people have challenged the constitutionality of police using algorithms? Another great question. There have not been yet, partly because we're still quite early stage in Canada. There have been in the United States, but the closest we've gotten to a case that's challenged something almost like an algorithm, there's a major case at the Supreme Court of Canada that came out within the past couple of years called R versus Ewert, E-W-E-R-T. And that wasn't an AI algorithm, but it was a risk assessment based on a formula to predict someone's risk in the corrections context. And so what happened was, this wasn't an algorithm, because an algorithm is an automated computational formula. Whereas this formula, it was like a piece of paper that showed all these different factors, and each of them was worth certain points, and then you add it all up at the end, and then the person gets a certain score. And that differs, and so that's almost like a manual algorithm, because you can see exactly what all the inputs are and how they're each weighed. It's not a black box the way an automated machine learning algorithm would be. So this risk assessment, was used on an Indigenous offender, and he argued that it wasn't a fair test. It wasn't a fair or accurate assessment, and it was actually discriminatory because all of the research that test was based on didn't include Indigenous people in it. So it couldn't possibly apply to him. And the Supreme Court agreed, so they did challenge it on a constitutional basis under Section 7 and 15. So life, liberty, security of the person, and 15 is equality. And they won, but not on those grounds. They won on the basis of Correctional Services Canada having a duty of accuracy when it comes to making decisions about inmates and prisoners. And by using this test that was already widely known to be inaccurate when it came to Indigenous offenders, by using that test on an Indigenous offender, they broke their duty of data accuracy. And then the court decided on that and not on the constitutional challenges. But we think it's partly because the facts didn't amount to it. The Supreme Court said that they weren't giving them the equality challenge or deciding on that because there wasn't enough evidence that this test was necessarily disproportionately, systematically discriminatory against this particular group of people, which is interesting because it suggests that if you could bring that kind of evidence for algorithmic policing technology in a future case, then they might be open to deciding it on those constitutional equality grounds. Why should we worry about police having info about us if we have nothing to hide? Also a great question, and a really popular one when it comes to privacy and surveillance questions, because it's true, different people will have different levels of concerns and worries when it comes to police surveillance. But there's still a few reasons that I would suggest people should care about this. The first one being, you may think you have nothing to hide now, but it doesn't mean you won't have anything to hide in the future. If you think about throughout all the different phases of history, who has been in power, not been in power, who has been attacked and marginalized and vilified and who has not, or things that used to be illegal, which now are not, or vice versa, you never know. And so even though things may be fine now, you may still want to have the constitutional protections and the freedom to be yourself in ways that aren't harming other people in the future. But that's just like the very first level answer. The other is that you may not have something to hide, but that doesn't mean other people don't have something to hide, even though they shouldn't. So if you think, for example, of national security forces targeting Muslim people, for example, or again, Black and Indigenous people being targeted for their activism, or environmental protesters, or even journalists sometimes, all of these are people who have been wrongfully spied upon and surveyed because they're fighting for their civil rights, essentially. And so you can't selectively say, okay, these people should have privacy rights and these people shouldn't have privacy rights, right? It's kind of like a rising tide lifts all boats. And so if the rising tide is our human rights, then why would we not want the highest standard possible to protect the most vulnerable among us? So I guess another way to say that is that it's not about you. It's about other people who might need privacy rights more than people who, you know, don't need to fight for their equality rights because they already are part of dominant groups in society, for example. Or because they're not engaged in activism, they're just, you know, living their own lives, keeping their heads down or whatever. And then the third response to that thinking is that privacy, again, it's not about hiding. Privacy isn't about secrecy. It's about control and choice over your information, over who you share, to what you share, and how, why, and when you share it. So again, if you have, say you have 1,000 Facebook friends and you post something and only show 500 of them and not the other 500, that is you exercising your privacy right. You still showed it to 500 people, but the fact that you hid it from the other 500, that's you exercising privacy. Another way to think of it is, so Edward Snowden, who is the NSA whistleblower, the way that he puts it is that everyone knows what happens when you go to the bathroom, but you still close the door. So it's not a secret what's happening in the bathroom, right? But if you have nothing to hide there, then why close the door? And that's just, to me, the best way to distinguish between what's secretive and what's privacy. And then the final word on that, I think it may also be a Snowden quote, which is basically goes back to people having different amounts of vulnerability and needing different levels of protection in society, which is saying that you don't need privacy because you have nothing to hide is like saying you don't need freedom of expression because you have nothing to say. Okay, wow, everyone is incredibly engaged. This is amazing. Okay, how can I find out if the police have information about me in their databases? That's a great question. I think I would direct you to look up access to information and freedom of information requests, as well as, yeah, I think I would point to that avenue, and then there should be a way for you to request information. I'm not sure how successful that would be, but that is one way you can do it. Can you tell us more about the Missing Persons Project using algorithms? Isn't that a good idea? Are there safeguards that can make it more likely to be socially beneficial? So, are we still on?
Yes, we are.
Oh, okay, strange, something happened. Okay. Sorry, Microsoft Teams started glitching on me. Right, so the Saskatchewan Predictive Policing Predictive Analytics Lab is still quite early stages, so they haven't rolled out anything yet, and so it's hard to say too much about them. And yes, on the surface, it is beneficial, right? But again, it's all in the details, and it's all in the broader implications of what happens when you introduce technology into a pre-existing context, even with safeguards. But that's a question that has to be answered with more research. How protected are photos and files that are uploaded to cloud online storage, such as OneDrive, Google Drive, or Apple iCloud, from police access? Well, I think that essentially depends on whether the police is interested in your materials or not. So different companies have different standards and policies for what it takes to give information to law enforcement. Some of them may say, we're not going to give information unless there's a warrant. Others may say, even if there's no warrant, but it meets these criteria, then we will hand it over. So one thing you may be interested in looking up is that the major companies have started publishing transparency reports every year where they list how many requests they've had from law enforcement or from government for data, for example. And they also should have published policies that will actually list out what they require from law enforcement in order to hand over user data to them. Okay, you said laws haven't caught up to tech. What legal reforms would help govern algorithmic policing? Well, that's a great question. The first one is that we basically said that the first reform is that everything should stop until we actually have the time and space and lawmakers are able to do a full proper inquiry into the full implications of these, especially consulting marginalized groups and communities that are most likely to be impacted. So our first reform was to implement a moratorium on all use of algorithmic policing technologies across the country. Our second reform is mandated transparency, because transparency and access to information was a huge problem throughout this project. I mentioned all these examples of technologies that police were using for years before the public knew about them, and that shouldn't be the case. We should know about them before they're implemented so that we can be consulted on them and decide as a society whether it's something we think it makes sense for the police to have or not. So we also recommended immediate disclosure of all policing technologies that are being used right now in Canada, and then on the longer term basis, regular, maybe annual reports, transparency reports that list what's being used, as well as public notice and consultation before anything new is adopted, so we can actually give some input and provide different perspectives that law enforcement agencies themselves may not see when they implement a particular technology. Another example of a legal reform is that we said whenever, as part of this assessment of implementing a new technology, there should be what's known as an algorithmic impact assessment, which is exactly what it sounds like. It's assessing the full range of potential harms and impacts that might result from the introduction of this particular technology.
All right. So that was wonderful. You've really put Cynthia through her paces with a long list of questions. This is the last call for questions. Oh, and one just popped up. Here we go. One last question. Thank you, people.
Okay, does predictive policing go against social media policies? That's a really good question. And I love this question because it highlights something that I'm particularly interested in, which is the specific relationship between social media companies and law enforcement agencies. Because what you have are public corporations that generally operate under one privacy regime, i.e. consumer privacy law, and then on the other, you have law enforcement agencies that operate under a completely different privacy regime, i.e. the Constitution. And so what happens when they start linking up with each other, like whose privacy regime reigns, basically, and if you're not careful, you can end up with the police finding a workaround around our right to be free from a reasonable search and seizure because they can go through the company and get data that they may not have otherwise been allowed to on their own. So with respect to social media policies, it really depends on what specific technology we're talking about. So if you recall, we covered a range of technologies in our report, and each of them works in a different way. And so each of them might have different legal issues involved and might also be treated differently by a social media company. So for example, something like Media Sonar, we know was banned by Facebook and Instagram and Twitter because it was seen to be advertising to police agencies. You can use this to target Black Lives Matter activists. And these social media accounts decided that that went against their policies, and they banned Media Sonar from accessing their API. Recently, with the Facebook Friends List feature, the Friends List unlocking feature I mentioned, so the reporter actually told Facebook about this, and within a week, they banned that tool as well. So if we look at what happened with Cambridge Analytica, for example, there are social media policies in place that you could probably look at, okay, the technology works in this specific way, here's what the policy says, on a technical level, this does go against the policy. But that may not necessarily be enough if they're going ahead and doing it anyway, and it doesn't seem like there's necessarily proactive monitoring. For example, Facebook didn't know about Media Sonar or about this other tool, unlocking tool, until they were told about it after the fact, and then they did something about it. So there's the policies, whether they're sufficient, and then there's also enforcement of the policies. Okay. Great, last question.
Absolutely. It really, really was. And I think that at this point, it's time to say a very heartfelt thank you to all of the students and teachers who attended this session, who asked wonderful questions. To Cynthia, of course, for sharing the work that you do, introducing us all to the huge range of ways in which technology is changing the way policing happens, and the ways that we need to think about how we as a society can ensure the necessary protections for rights and freedoms actually get built in to the policies and practices around these technologies as they change and evolve. So thank you, Cynthia. We really appreciate your taking the time to share your expertise with CCLA and all of our student and teacher participants today.
Thank you so much.
I'd like to invite the students and teachers, of course, to join us again this afternoon for our second sessions of the day, which begin at 2:50. That's 2:50. Thanks again, everyone, and have a wonderful rest of your day. Bye-bye.